Thank you, Chairman Stile, Ranking Member Morelli, and members of the committee. Thank you for the opportunity to testify. I'll apologize up front. I lost my voice a couple days ago, and so now I'm relegated to sounding like Wilford Brimley or something. Or the coach from Major League. My name is Satya Thallam, Senior VP at Americans for Responsible Innovation, Senior Fellow at Foundation for American Innovation, and perhaps most pertinent for this hearing, for a number of years I was a senior staffer at the Senate committee that had primary jurisdiction over the Administrative Procedure Act and all regulatory process related issues, and later worked at ARI, which Paul mentioned. So in this testimony, I hope to make three basic points. First, if you'll pardon the slightly obtuse metaphor, federal policymaking follows something like the first law of thermodynamics. Energy in the system can move between different parts of or change form, but it is neither created nor destroyed. What this means is if one branch does not energetically exploit its prerogative to make policy decisions, those policy decisions will be made elsewhere by the other branches. Like a balloon, squeezing on one part will simply move the gas to another area. Ambition must be made to counteract ambition, as Madison said, but apathy is not met with symmetrical apathy. What the court has done has used its own prerogative to reassert a new equilibrium. And yes, this has the effect of empowering the Article I branch, but this effect is not self-executing. It is right now a kind of potential energy, waiting for a force to be applied, turning it into kinetic energy, to further torture my classical mechanics metaphor. Second, let us remember that the original Chevron decision itself ultimately permitted agency discretion in that case, and what most people agreed was a deregulatory direction. The EPA had wanted to permit more flexibility in regulatory compliance, making an existing rule less constraining. So the Chevron decision, not the most recent decision, but the original Chevron decision, and now Loper-Bright are neither, quote, regulatory or deregulatory. This formulation makes no sense. Further on this point, the APA does not contemplate a thing called a, quote, deregulation as something afforded a differential process. The APA defines rulemaking as, quote, agency process for formulating, amending, or repealing a rule. In other words, everything, any change to the Code of Federal Regulations is similarly situated and is not tilted in favor of one or the other. Third point, and I believe at least some, if not all of my colleagues on this panel will agree with this, with the need, maybe not even limited to responding to this decision, to increase congressional capacity. As the sole branch of government constitutionally vested with legislative powers, it behooves Congress to be best equipped to execute that responsibility. In naive terms, Congress is worse off. Since this decision, contrary to the hearing's title, is actually a return to the pre-Chevron regime, let's go back. In the 40 years since the decision, the total number of congressional staff has actually decreased, has actually gone down by a few percent. In the last 30 years, the number of committee staff has gone down by 40%. Does anyone on the committee believe Congress's work has become less complicated, confusing, and therefore easier since then? Members of Congress may be wary of the self-aggrandizing appearance of accumulating more staff. But human capital and expertise are embodied in people, and this kind of a decrease in intellectual capacity has only one result in terms of productivity and effectiveness. This is admittedly a crude measurement of congressional capacity, but I hope you get the point. Finally, an anecdote on this capacity on a slightly related thing. Many of you are familiar with the Congressional Review Act and its requirement that a report be submitted to Congress for review for every new rule. Well, in 2020, for obvious reasons, the normal processes for submitting those reports, which at the time were all done by hard copy, were severely challenged. When I inquired with various offices to find a solution, like submitting those reports electronically, therefore they'd have a timestamp of the receipt and then follow up with hard copies, I was told emphatically, we do not have the capacity to set up such a system. I don't want to be too precious about this point, but if Congress hasn't made even modest administrative updates to fairly mundane processes, how can we believe Congress is equipped to handle an increasingly complex, unpredictable, and fast-moving 21st century? Thank you, and I look forward to your questions.
Thank you very much.